What I'm going to do here is model for you how I'm going to go through some steps of close reading a case in preparation for writing a case brief. I am going to be using a Westlaw printout of In Re Marriage of May, which is the case that we were playing with in class, and that is the one that has these sample briefs available on D2L. So with this copy, what you can see is that I've already put in a couple of annotations to show you where the different components are. You can see it starts off with the caption. Just above the caption are some additional parallel sites that you can use to cite the case, the deciding court, the parties, the docket number, the date of decision. Most of the other components that we talked about in class are actually labeled right on the print. So for example, right over here is the synopsis, labeled with synopsis, and headnotes are also labeled right here. Now remember, none of the synopsis or the headnotes are going to be binding law. This is not the precedent, but what an editor has done to the opinion itself to make it maybe more user-friendly or to be more helpful in research is something that we're going to be discussing in the next few weeks. Other components are labeled down below. You have where the actual law and precedent starts, which is right here, and the opinion follows. Remember, we start off with the name of the judge who wrote the opinion. At the end, I have labeled this is the disposition, and then the remainder of the panel that decided the case is down in the back. I haven't done any of the other steps necessary for my close reading. I haven't gone through the West headnotes yet to figure out if there are other topics in here that do not touch on marriage. Again, remember, I'm reading this case because I have a client who has a question about whether or not her marriage is void or voidable, in other words, whether or not she can seek an annulment. So I'm going to concentrate my work on those sections, not necessarily the other sections. The other thing I noticed is that as I scrolled through the case, this is actually a pretty short opinion. So because it's a pretty short opinion, it's less important for me to try to narrow down the areas that I want to concentrate in using the headnotes. If I wanted to concentrate on something in a headnote, remember I look at the number I'm circling right here, right? Headnote 3. If I'm really interested in what's in headnote 3, I can come down into the body of the opinion and look for the 3 in brackets, which is right here. So if I was really interested in the topic discussed in headnote 3, I can find the court's discussion of that topic starting here at number 3 and going forward. So I go back and I look at my headnotes because I am just going to skim first. I look at the headnotes to see what's going to be covered in this case opinion. Okay, so it's going to be starting here at headnote 1. Second husband could not have marriage declared void, couldn't get an annulment where he lived in a conjugal relationship with the wife for almost 4 years. Okay. Cohabitation required under the statute. Okay, it doesn't have to occur with knowledge. All right, so that's going to be another marriage piece. I'm reading here, headnote 3. Overriding objective in interpreting statute is to ascertain and give effect to the intent of the legislature. Okay, so what this tells me, what this headnote here, number 3, tells me is that this case is going to talk a little bit about statutory construction. I don't care that much about the steps of statutory construction right now. That's not what I'm looking for. But now I know this opinion is also not just going to talk about marriage and annulment, but it is also going to talk about statutory construction rules. And that is the rules that we use when we're trying to interpret what a statute means. So I keep going, headnote 4. It's more statutory construction stuff. Number 5. More statutory construction stuff. 6. Appellate court reviews questions of statutory construction de novo. Okay, so more construction stuff. By the way, what this means right here, this appellate court reviews questions of statutory construction de novo. That's the standard of review. What this tells me is that the appellate court, because this is seeing this as a question of pure law, of how the statute should be interpreted, it's giving absolutely no deference to what the trial court said. It's going to be making its decision in this case brand new, as though the trial court never even touched it. All right, 7. Parties to a prohibited marriage. Okay, so we're going to get back to talking about marriage and this relevant law. Okay. Just cruising through 8. Bigamy. Okay, so this is more discussion of the marriage and annulment. Okay, and 9 is got the same sort of feel. Okay, now I'm going to take a look. I'm going to just cruise quickly through the opinion, skim the opinion to see how it's structured. Got an introduction, and this introductory paragraph right here starts to highlight for me some of the issues or what the main issue will be. So I'm going to label this intro. And the court has labeled it says, but the fundamental question. So this tells me this is where the issue is going to be. So I'm going to label it. Next, I have facts. So skimming through these 2 paragraphs of facts, I see in the first paragraph, those are what I called in class, and for lack of a better term, facty facts, like what happened to the couple before they got to court. So these are facts. Second paragraph, more facts of what happened between the couple. Third paragraph, those are going to be after the trial court entered the judgment. So these are going to be what we call procedural facts. So I'm going to label them that way. Okay, so remember, procedural facts are what happened once you got to court. Once somebody filed the lawsuit, once somebody filed the petition for dissolution, for divorce, or for an annulment, what happened? Those are my procedural facts. That tells me where we are in the court process and what might have already been decided by lower courts. Okay, now below that, I have the discussion. So under the Illinois Style Book for Opinions, I know that the court is supposed to label the area where it starts setting out what the law is and how it applies the law to the case facts are supposed to be labeled with discussion, which it is here. So I'm scanning through, and once again, I have issues stated once again. Sole issue, so there's one issue. And again, skimming. Now, remember, when I found all those head notes was 3, 4, 5, 6. All were talking about statutory construction. So as I skim through this paragraph with 3, 4, 5, 6 in the head, I see there's a bunch of rules. I know they're rules in part because they're flagged by these case citations. That's a great indicator to you that that's going to be a rule or law. So I'm looking through here and I see all these are rules about statutory construction. Once I get down here, the next paragraph, section 212. Okay, so now we're talking about the marriage laws. So that's going to be more the law and rules on the issue that I care about. So I'm going to just label that down here like this: law, rules. And then I see more discussion of Tommy and Tamara. Well, in my skimming, I saw that those are the names of the 2 parties. So now I know we're talking about the folks who are involved in the case. So this might be some application of the law to to the complainants, to the litigants here. Skimming through again. I see, in addition, a critical reading of Section 212. So this may be some more law and rules or interpretation of that. I'm not going to label it or talk about it yet. I'm going to wait till I'm more closely reading to choose what I want to highlight there. Get down to Head Note 7. The foregoing analysis does not foreclose the possibility. Okay, so that tells me that what I've just skimmed past quickly are probably the holding and the reasoning of the case. Tommy also claims that. Okay, so that's going to be one of the parties' positions in his complaint about the trial court there. Okay. And the court at the end rejects that argument in the next paragraph. And the judgment of the circuit court, the trial court level here, was affirmed. I see that there. Okay, so now I've skimmed through, and I understand from my skimming that we have two different sets of rules or laws involved here. We have marriage law involved, and we have statutory construction. I'm not that interested in the statutory construction, but this is such a small opinion. I'm going to read the whole thing closely. When the opinion is only a couple pages long like this, it's not going to be something that you need to cut out. You may encounter opinions in your research and your further work in the future that are like 50, 60 pages and that may have extensive discussions on issues that are completely irrelevant to your case. And in your beginning reading, you're probably going to be skipping those sections that are completely irrelevant. Eventually, you do want to make sure you read the whole thing because you can find little golden nuggets of what you really do want hidden in those sections. But it's not that important for me to prioritize what I'm going to spend a lot of time close reading on when the opinion is so short. If the opinion is this short, I can read the whole thing pretty closely after I get the lay of the land. So that's what my next step is to go closely through the opinion and make notes and I will also not only make notes on my printout like I'm doing here, but I will also make notes maybe on a side piece of paper or on my computer as I'm trying to put my case brief together. So I will do a little less talking here, but I am going to start underlining and making more notes to show you how I go through my opinion. What I'm underlining here are what I think are going to be the critical facts to the underlying dispute. You'll notice I didn't underline the names of the kids and the years they were born because those actually aren't critical facts. I don't really need to worry about those. Those really don't affect the outcome of the case, why the court decided what it did. Okay, so I've underlined just some of the facts that are coming before the procedural facts. These are the ones that I think are going to be most critical, and I'm going to include in my brief of the case. Now, again, I'm just making notes and trying to actively read right now. I'm not trying to completely brief the case just by making notes on the page. Eventually, you're going to be able to do that, but right now, when you're just learning how to read cases well, these are your preliminary notes. This is interesting to me. This is what the trial court ruled and why. This isn't really super important because, again, I already know that they're not going to give any deference to what the trial court decided, but this might help me understand what's going on and why we're on appeal. Oh, you know what I found in here in this paragraph? I found a little rule hiding out. It's actually a piece of the statute. So I'm going to label that separately as a rule. There we go. And it's actually this section 212 of the Illinois Marriage and Dissolution of Marriage Act. Parties to a prohibited marriage who cohabit after the impediment is removed are married as of the date the impediment was removed. That's going to be an important rule. Then I get more of the procedure of what happened. Okay, so then there was a motion to reconsider, and that was denied, and now we have this appeal. Okay, cool. Under the issue, I want to see, I'm really trying to narrow down what is the legal question before the court. The legal question is whether the cohabitation piece required by that rule I just underlined above, right, whether that piece must occur with the knowledge that the prior impediment to the marriage has been removed. In other words, what's going on here is the court is considering whether or not Tommy, right? Because if we go back and look at the facts, Tommy thought that the earlier marriage was being dissolved, but he didn't quite know if it was. He was taking his wife, Tamara's word on it that it was just, they were just waiting for it to get finalized in court. Clearly, if you look at the dates, it was a little bit longer than a few days. It was a year or two. But okay, so what we're looking at here down in the discussion is the issue is whether Tommy needed to know that it took that long for that first marriage to get dissolved. And that whether he needed to know that staying together with Tamara after that was going to validate their marriage. That's the question. The question is, did Tommy need to know that the first divorce didn't happen until later? Okay, now it's getting into the statutory construction stuff. All right, here's some more important rules. Section 212, which we had a little bit of earlier. Here's another rule, another piece of that statute, which was a little summarized before. All right, so right here is the defendant's position. So I'm going to just use a delta for defendant. Here's a rule hiding here. Bigamous marriage is void ab initio. More rules. There's more of the defendant's position down here, or respondent's position, I should say. Tommy claims that 212 can only validate a prohibited marriage if the parties cohabit after the impediment is removed and both parties know that the impediment has been removed. Okay. And I can tell right now this is not going to go well for him because the court says this position is untenable. The next paragraph, I am actually getting some of the court's reasoning. This is where the court's applying those statutory construction rules to its interpretation of the statute. So when they're saying since the term cohabit is not ambiguous, they're going to apply the statute as written. They're not going to use any other statutory construction. It's just going to use plain and ordinary meaning. Accordingly, we cannot read a scienter requirement into 212B of the Act. That's actually part of the court's reasoning for this opinion, but it's not the reasoning that we're going to care about. What we care about is when a marriage is void or voidable, we're not that interested in how the court reached that opinion. So I'm not going to highlight that. That's not one of the things that I care about as I read about this case in light of my client's question of when is a marriage valid versus invalid? When can I get an annulment? This is an interesting part of the reasoning over here. What it's telling me is that first marriage, that wedding ceremony that Tommy and Tamara had to mean something, and that the legislature intended for it to mean something. Since it couldn't create a marriage alone, because Illinois doesn't recognize common law marriage, we can use that marriage ceremony to satisfy the intent required to make this a valid marriage. Here's some more important rules. So what I see in the next paragraph is actually something that's not quite dicta, but it's on the edge. Now you'll remember maybe from ALS that dicta is the court's opinion on an issue that it didn't have to decide. So what the court is saying here in paragraph 7, paragraph labeled with the 7 from the head note, is that lack of consent and bigamy are two separate defects, two separate reasons that one might be able to get an annulment. But here, that's not going to be relevant. Right, so here's a phrase that we want. We hold. So this is the court's answer to the issue. The holding is the court's answer to the relevant legal issue that you care about. So we hold that Section 212R operates to ratify a bigamous marriage regardless of whether the parties knew that the impediment has been removed. So that's the holding. The holding answers the question posed in the issue. I'm labeling it, and this is the way I will label it in your papers, an H with a circle. Here's another rule. Now, actually, I've been going through it, and as I'm quiet here, I'm actually reading these paragraphs multiple times. As I'm actively and closely reading a case, I'll read down some, and then maybe I'll stop and go back and reread a few lines before. So that was a rule. You know what this is over here in this paragraph? This is the reasoning. R with a circle. This is why or how the court decided what it did. Okay, so now I've actively read my case. I've made some notes. I might need to go through a few more times. I might need to grab a legal dictionary to look up some terms that I didn't understand or I didn't know. I might circle those terms in my notes so that I can go back and find the words that I need clarified a little bit more easily. Or maybe I'll use a highlight, or maybe I'll pick a color and highlight each word that I care about that I need to look up. But I've actually read through a couple times now, and maybe I have to go back and read again and make some more notes. Once I feel like I have pretty good notes and I really understand what's happened in the opinion, then I'm actually going to start putting my pen to paper or my fingers to keys to write up my case brief. And for some good case briefs on this, please look at sample case brief A and sample case brief B in your materials. If you have any questions, please come see me. Happy to help. So is Marianne. I hope this was helpful to you, and I look forward to seeing you next week.